Right. Good afternoon, everyone. We're just waiting for people to join in on the webinar. Great. Just give it a couple of minutes, Zubair. I think people are still joining.
Sounds good.
Right. Well, I don't know if anyone's able to put in on the chat if you can hear us before I start talking without that.
Can't see any messages.
Good. Thank you, Alice.
Yeah, got it.
Oh, chat's disabled. Oh, brilliant.
That's
Okay.
disabled, but they can.
Francesca,
Yeah,
your messages come to me at least, so that I appreciate that. So I think if you put those messages in, they will appear as questions for us or comments, so we can see those. All right, Zubair, just if nod if you can hear me.
I can hear you.
I'm not sure if I can hear you.
I can hear you, James.
You can hear. All right. Okay. Well, everyone, let's kick off then. We've got most people here probably who are going to join. Well, first, thank you for coming this afternoon. Apologies that this is really an adjourned webinar. Zubair and I were due to give this session a few weeks ago, but due to a few personal circumstances, we were unable to do so at short notice. So I appreciate you all for rearranging your diary so that you can hear us. For those of you who don't know, Zubair and I are members of One Pump Court family team. We both practice in financial remedies and in private law, and I also practice within public law. Zubair, you will correct me to say if you also do a practice in public law, but I'm afraid I forgot to ask you that question
No, I
before
do
we
a very
started.
little amount of public law and a very little
I
amount.
can't actually hear you, Zubair, so that might be an issue at my end. That's better. No, that was my fault. I had the laptop off for court and I didn't turn it back on again.
Okay,
Um,
no, I do a very little amount of public law and a very little amount of immigration as well.
that's right. Okay, great. So yes, that's right. Your um, practice emphasis certainly is financial remedies and some private law.
That's right.
So what this session really is to look at the issue of setting aside a financial remedy order. We're going to go back to basics, which is always my starting point, and really run through that and hopefully have some time for any questions at the end. So perhaps without further ado, Zubair, you can kick us off there with the statutory frameworks and where we all start.
Sure. Thanks, James, for the introduction. So firstly, it's good to start off by looking at where does the court have the power to vary or set aside a financial remedies order. So the power comes from Section 31F of the Matrimonial Family Proceedings Act 1984. FPR 9.9A is helpful in that it defines what setting aside means. It means to rescind or vary a financial remedies order pursuant to subsection 6 of 31F of the 1984 Act set out above. Now, there's the FPR also sets out circumstances in which an application to set aside an order should be made in circumstances where the applicant didn't attend the court hearing. So the first example would be where it was where the hearing took place and it was and no notice was given of that hearing. And the application must be made in 7 days. FPR 18.11 sets that out. And the other situation is where notice of the hearing was given, but the applicant to set aside did not attend that hearing. You obviously have to explain why he didn't set aside, if there was a good reason, whether there was a good reason for his non-attendance. And that's set out at FPR 27.5. But the focus of this seminar won't be on those situations. It's going to be the situations where there has, for example, been a contested hearing or even a hearing at which an order was made by consent, and then a party wishes to set aside an order that was made at a hearing. So that's going to be the focus of this seminar. So one important point to consider is setting aside is quite different from appealing. And if the court to which you're making an application to set aside sees your application as sort of a backdoor attempt to try and appeal the order, then it's probably going to give short shrift to the application, and it's probably not going to really it's probably going to tell the applicant, well, what you should be doing is appealing rather than applying to setting aside. But if someone is applying to set aside, the application should be made to the same court, same court which made the order in the first place, the order which the applicant's applying to set aside, and the Part 18 of the FPR should be followed. And it's the same level of judge who's going to consider the application to set aside. So, James, I've set out the very basics. Can you tell us the basis on which an application to set aside can be made?
Yeah, of course. I think just picking up on what you said about backdoor to appeal, we're going to look at a case study of a case at the end. It's the XYXX case. And they're the same points made that if you're looking at an error of law that you want to claim has occurred, really the remedy is appeal. But where you're looking to set aside in this course of action, it's really a case of looking at the facts and whether the circumstances on the ground give rise to any grounds to set aside. So on the slides, we have put over the headings of the various known grounds, or really categories for the basis of a set-aside application. When you're looking at a set-aside, really what you're saying is the outcome that was reached at the conclusion of the financial remedy proceedings is an unjust or unfair outcome as a result of a new set of circumstances either arising or that you have become aware of, that means the final order made was wrong or should not have been made in the way that it was. So these are the headlines that we'll be going through. So I'm going to take a bit of a deeper dive into that first heading, which is the non-disclosure of material evidence. Now, really, this builds upon the fairly well-established and obvious duty, which is that each side or each party to these proceedings need to be transparent and provide full and frank disclosure of their financial means and the evidence that relates to that. Now, there are going to be several cases where we don't see full and frank disclosure. And we have lots of cases that we come across where our clients tell us that they're not satisfied, that the other side has provided full and frank disclosure. And part of our job and duty is to try and navigate the evidence that we see, to try and identify any areas where there are gaps in the disclosure. But there may be some cases where, subsequent to the final order being made, you come to realise that there has been a material and significant non-disclosure during those proceedings. So the first point to consider is the non-disclosure event, the type of the non-disclosure that you've come across, is it a material disclosure? In other words, had the court had sight of that disclosure, which it didn't in the first instance, would it have substantially made a difference to the outcome had those facts been known at the time? Now, there can be what's proven to be deliberate disclosure, i.e. the party to which the information relates has deliberately concealed that information. Now, if that's the case, it is presumed that the material that has not been disclosed is a material non-disclosure. So if you are responding to a set-aside application upon which the ground is non-disclosure of material evidence, if you are the party who is alleged to have failed to disclose it in the original proceedings, you would then have, and it can be shown that that was deliberate, you then have the burden to demonstrate that the fact of the non-disclosure would not have led to a substantially different outcome. So that is your first line of defense if you're responding to this ground. On the other hand, if the non-disclosure was inadvertent and not a deliberate act, the burden to establish that the outcome would have been substantially different remains with the applicant. So that's certainly something to bear in mind in terms of where the burden of proof falls to establish that the fact of the non-disclosure would have led to a substantially different outcome, or in other words, a final order on substantially different terms. Now, let's assume that you, in theorizing the application, consider that you have got a material non-disclosure that would have conceivably led to a substantially different outcome. When advising clients what they might expect in terms of the length and nature and potentially costs of going back to court in the set-aside application, it may be that if the nature of the non-disclosure was broad in its range, in that it impacted the majority of the distribution of the assets originally, the court is going to have to start afresh and complete a new Section 25 evaluation in terms of how it's going to newly distribute the assets as they now are, given the new information arising from the disclosure that wasn't the case in the first proceedings, but is now available in the set-aside proceedings. Or if it's more of a nuanced but material non-disclosure, it might be that parts of the original order are not likely to be affected, and therefore the new evaluation on the distribution could be limited in scope to the assets or type of financial asset that is only related to that non-disclosure event. So that would mean the application to set aside could be focused to part of the final order, which relates to the non-disclosure, and that might be a more limited procedure by the court, or more limited second evaluation by the court in terms of determining the application, or it could be a completely fresh evaluation depending on the impact of that non-disclosure. So non-disclosure of material evidence then, quite an important ground on which you could apply to set aside, but there are those multiple stages, whether you're applying or responding, that you need to be aware of, which will also allow you to advise our clients on the potential extent and scope of any new evaluation that the court sees with the set-aside application will need to embark upon. Over to you, Zubair, for another of the grounds.
Thanks a lot, James. So I'm going to just briefly touch upon fraud. Now, fraud's obviously, the person alleging fraud will probably is going to have to prove the allegation of fraud. But once again, the court, I mean, the key authority there would be Shartland. Shartland's a Supreme Court case, and it would, and in the absence of full and frank disclosure, the court would have to be satisfied that the order that it would be making was substantially different from the order which it would have made if such disclosure had taken place. It's quite, I mean, it's very similar to the non-disclosure of material evidence points which James has raised. So I'm not going to focus on this ground significantly. The next ground is really BARDA. The BARDA applications, the BARDA and BARDA, it's a case from 1988, and these are this ground arises in relation to events which occur after the final order is made. Now, I've referred to the case of BARDA and BARDA on that slide, and it sets out the 5 principles that the court will apply when looking at whether or not the events which occurred after the final order is made are as such which warrants the setting aside of the final order which the application is based on. I'm not going to read that out, but what I will do is give you some examples of situations where the court has set aside a financial remedy order on the basis of events occurring after a final order is made. So an example is the case of Williams and Lindley, the 2005 Court of Appeal case. So it's EWC A Civ 10103, and 2005 is the year from which the case is from. And in that case, the order was set aside after the ex-wife, in that case, married a wealthy new partner within 1 month of the date of the final order, and it was invalidated. So the final order in that case was invalidated. But that does not mean that simply because someone has remarried, that that's a ground for setting aside a final order. That isn't, and we know that from the case of Dixon and Marchand, the 2008 case, the reference is 2008 1 FLR 665. Other examples of which of situations where the court set aside financial remedy orders because of events occurring after the final order. There's a case of Nasim and Nasser, 2015, EWFC 2620. And in that case, the court, the order was set aside. The court was satisfied that the order should be set aside on the basis that after an event, that the children in that case, they were spending significantly more time with the mother in that case, and six weeks after the order was made, the children were living with the father on a 100% basis. So essentially, the Section 25 analysis which the court would have undertaken in the case of Nasim and Nasir at the final hearing would have been wrong. It would have been wrong. It would have been, and the outcome would have been unfair on the basis of the events which occurred after the final hearing. There are other examples as well, but essentially the focus will be on the 5 criteria, which is set out on this slide, and the court will really be focusing on whether or not the events which have occurred, well, firstly, whether or not they occurred within a relatively short time after the final order. The court will also be considering whether or not an alternative mainstream relief is available to the person who's the applicant who wishes to make the application to set aside the financial remedies order. James, that then brings us on to the next slide, which is lacking capacity. And the next ground after that is mistake. And I'll leave it to you to cover those 2 grounds.
Thanks, Zubair. Yeah, so lacking capacity really is a very narrow ground, and it sort of says what it does on the tin. If at the time the final order was made, it's subsequently clear that either with regard to a consent order or in relation to any other type of order where the party was participating, they had serious mental health issues, you may have grounds, therefore, to set that aside and to revisit the question of that evaluation. There's not much more to say on that one, so I'm going to move on to the more, I think, useful ground in the sense that it's one more likely to occur, which is the ground of mistake. This ground will tie sort of rather neatly into the case study we've got in a short while, because it was really a mistake within that case that we want to explore. So the slide really lists a High Court judgment by Mostyn in the case of DB and DLJ. These are sort of the 6 criteria that one would apply to potential mistake that has occurred to establish whether the ground could apply. So just to run these through. So where the relevant facts exist, that the order is made unknown to the parties at the time of the order, there was actually a mistake that is relevant to the outcome of the order. Upon satisfying these conditions, a party might be successful in setting that aside. And obviously you might want to do that if the mistake materially adversely affects the real life outcome of the distribution of those assets. So the first one, the applicant needing to show that the true facts, i.e. the facts without the mistake, would have led to a materially different outcome. So that's very similar in context to the non-disclosure point. Was the new information, the mistake in this case, or the disclosure in the previous example, going to lead to a material or substantially different outcome? And if the answer is yes to that, then of course the court's going to be interested. If the answer is no to that, then for public policy reasons, the court will be slow to try and go behind previous order. So assuming then that the new facts would have made a material difference, you then want to be able to establish that the mistake or the absence of the facts from the original proceedings was not the applicant's fault. Really, that goes to public policy reasons for the court wanting to discourage improper due diligence to ensure that everyone properly investigates their own financial information by really making sure that if it's your fault or your client's fault that you haven't been able to produce the true information at the right time, you don't get a second bite of the cherry, which I suppose makes sense. That really just reminds us of our duties to carefully look at the information with our clients and also to tell our clients that they don't have a second chance realistically. Unless, of course, it's not their fault. So, thirdly, the applicant needs to show that with the correct due diligence, that information could have been established at the right time. Because, of course, what the court's looking at is what was the information before the first instance court, and was there a mistake in that within that evidence set? It's not obviously looking at a change in circumstances, which is more relevant to the grounds that Zubair was talking about a moment ago, where there's been a significant change in circumstances after the fact. So if that's the case, that wouldn't be a mistake. That would be a significant change in circumstances. The next point really is just a point of procedure, which is to say, look, if you realize there's a mistake, you need to be making the application to set aside promptly. And what is promptly will really turn on the facts of the case. But you need to be able to, with confidence, say that this application has been made after the final hearing, as soon as reasonably practicable, once it's become known that there was a mistake in the evidence, and that not enough time has passed such that the court is going to say, for policy reasons, that it's no longer able to revisit the original decision. Fifthly, so again, it's whether or not there's an alternative mainstream relief that might remedy the injustice caused. Again, that will turn on the facts of the case, whether there is another remedy or whether it's a case where really the court needs to revisit that distribution evaluation. And finally, we have the sensible point, which is if there have been further transfers for good value and in good faith, that third parties can't be affected. So there might be some cases where the nature of the assets and the transfers means that in reality, the court can't revisit its decision because subsequent transfers has meant that the assets are no longer available. But it might be that, notwithstanding that issue, the sort of money in the pot, as it were, the liquid asset is still available, and so there can still be a re-evaluation of distribution. So I think that sort of brings us to the conclusion of our run through the various grounds, in theory, where we can either bring or respond to an application to set aside a final order. And then we just want to spend sort of the next 5 or so minutes, or 5 to 10 minutes rather, taking you through a case study. So X, Y, and XX. So it's a fairly recent decision. It's England and Wales Family Court. So it's not a case of authority, it's a circuit judge case. But it's an interesting example of how a court considered and dealt with and ultimately refused the set-aside application. So I'm going to, for those of you who aren't familiar with the case, just sort of run through, sort of in brief terms, the facts of the case, before handing over to Zubair to give us the insight into how the court reached its decision and what that tells us about the application of those grounds that we went through before. Really, this is a case of mistake, so that's the ground that we'll be focused on. So, okay, so what do we need to know about this case? Well, it was a fairly sizable pot of money. The final order um, essentially led to a distribution on fairly even grounds, leading to about 6.5 million each between for husband and wife. Um, Now the various assets were divvied up in such a way that we got to that approximate even outcome. But ultimately, the husband, who had much greater pension assets, had to pay a lump sum of just over £1 million to the wife in order to balance out the outcome. And then a clean break was attached to that. So in the end, the husband, who had some options as to how he could transfer part of his pension evaluation to the wife, elected to pay less of a lump sum and transfer 50% of his pension to the wife. So by the time that order was made, he hadn't paid. Sorry, by the time that he had to pay that money from the order, he hadn't done so, and so the wife made an enforcement application. And what she wanted to enforce was a sale of the marital home to generate the liquid asset to meet her share of the distribution. And about 4 months later, the husband made an application to set aside the original order. Now, the issue was that he had a number of properties which, upon sale, were going to generate capital gains tax. And capital gains tax had not featured in the really the asset table and distribution. And it had to be said, really, that the reason it had not featured is because the husband hadn't brought it up. And in fact, the husband's representatives had firmly indicated that, in their view, there was no capital gains tax to be concerned about. So the basis of the application was that the mistake in failing to recognise that capital gains tax would be payable, which was information that could have been known at the time but wasn't, because neither party had established it. The amount of capital gains tax was such that ultimately, once the properties were sold and the money was left in each party's pocket, husband would have a substantially less than 50% realistic outcome, having paid in full by himself the capital gains tax on the properties. So he said that was a mistake, and a material mistake that, had the court known, would have factored in the tax, and then a different distribution would have been arrived at. So court looked at that, but the court decided that father was the party responsible for identifying the need for capital gains tax to be, well, that capital gains tax would fall due. And he was in some difficulty, having not brought that to the court's attention properly in the first place. So, Zubair, I don't know whether this is a good time for you to jump in to make some commentary on what led the court to reach its decision.
Yeah, sure. Thanks, James. No, thanks for setting out the facts. I should probably just add, so the capital gains tax was in reference to property which was in Dubai. Now, and what happened in is, I mean, it seems fairly obvious in hindsight. I mean, when you're dealing with the sale of properties, if they will attract, I mean, if you're dealing with the sale of properties, you should instruct a tax expert to sort of evaluate what level of CGT they will attract. However, in that case, it wasn't done. What the judge does in his judgment, he sets out the transcript from the hearing before him, the final hearing before him, at which the advocates for the parties, or more importantly, the advocate for the husband, agreed, or nothing. He set out the figure in terms of the value of the Dubai properties, and absolutely nothing was said about tax. So throughout the final hearing, the court and the parties were working on figures in respect of the Dubai properties on the basis that they attracted no capital gains tax. So essentially, that's sort of just to supplement what James said and sort of give a bit more of a background in terms of how it came to be that CGT wasn't even looked at, or no expert was it wasn't considered by anyone that an expert should be instructed to assess what level of capital gains tax would be attracted. So what happened in the end is that the court dismissed the husband's application, decided it will not set aside the financial remedies order that it made. And so paragraph 58 of the judgment, the judge sets out his reasoning for why he decided what he decided. But what's really helpful to consider is what the judge says from paragraph 24 of the judgment onwards. What he does is that he sets out 6 principles. His Honor Judge Hess sets out 6 principles and then applies those principles to the facts of this case. And the first principle being the public policy, this paragraph 25, the very strong public policy of respecting the finality of sealed orders. The second public policy reason that it's incumbent on a litigant to bring to the first instance court hearing material to be relied upon and relevant to the issues before the court. And then the third reason, which is also this paragraph 27 now, which is also, I'd say, a public policy reason, that the court is likely to be slow to come to the aid of a litigant where a mistake has occurred, which is the fault of the person seeking to rely upon it to justify reopening of the order. And then also the fourth and fifth principles, which essentially all stem from the case of DB and DLJ, which James took you to earlier when we were looking at mistake. So I've brought up that slide again. And then paragraph 58 of the judgment, what the judge does, he applies the facts to the case. And his judgment is essentially, well, when I apply the 6 principles, the conclusion that the court reaches is that, well, no, the husband in this case shouldn't, that the final order shouldn't be set aside. What's really important, I would say, to consider is paragraph 58, subsection 5, and that's in consideration of the question as to whether or not any alternative mainstream relief, which has the effect of remedying the injustice, exists. That's essentially category number 5 or bullet point number 5 on this current slide. And the judge's view was, I'll read out what the judge said. The judge said that he's not privy to the communications between the applicant and his legal team, but it's not impossible that the husband has another route to obtain alternative mainstream relief, which has the effect of broadly remedying any injustice he may have suffered. Essentially, the relief which the judge, I presume, had in mind is that the applicant, if his lawyers had been negligent, then the applicant could bring a claim of negligence against his lawyers to remedy any injustice that he suffered. And that's quite important for lawyers, because what you want to be very careful to ensure that you advise your client at every single stage where it's appropriate to get the input of an expert to assess tax, for instance, valuation of property, whether it's chattels, whether it's gold. CGT is very important, even if, in this case, it was the applicant's view that the Dubai properties wouldn't attract any tax. I'll try and find the relevant paragraph in the order, in the judgment, but I believe his impression was, well, his property is in a tax-free zone in Dubai, as a result of which he will not have to pay any CGT. Then afterwards he comes back and says, well, no, I do have to pay CGT and it's not a fair outcome. But he didn't get what he wants, and what you shouldn't essentially do is try to correct errors after they've been made. So for lawyers, it's important to make sure clients are advised clearly. It's important that all options of valuation, calculations of tax are done, and applications are made well in advance before any final hearing and before any FDR, so negotiations can be done properly. I mean, the FPR says the appropriate time to make any application for the appointment of an expert is before the first appointment. So that appointment can be done then, and you can have an effective FDR. So it's something that should be considered at the very beginning of a case, not as the case progresses or not at the FDR or at the final hearing, because then an application at that stage might be refused on the basis that it's too late. So that's essentially the judgment, and that sets out. I mean, what I've hopefully done is set out the base on which the court refused, or I've been able to help you understand the base on which the court refused the application, the base on which the court applied the public policy reasons, and essentially concluded that, well, this case isn't a case in which the application to set aside should succeed. I should also highlight that the court, I mean, in that case, there was some delay in the husband making the application, but the judge did also say that he wouldn't have refused it just because of the delay. What the judge was very clear on was that the fault lies completely with the husband in that case, and he had the benefit of an experienced and expert legal team at his disposal, and despite that mistake occurred, and the husband could and should have exercised reasonable diligence to explore these matters before the final hearing and before any decisions were taken. The judge placed significant weight on the public policy reasons I set out earlier. So the public policy reason of respecting finality of sealed orders, the public policy reason, or the public policy of the principle that it's incumbent on a litigant to bring in the first instance court hearing all the material that he or she relies on to determine issues before the court. So that's hopefully a helpful summary of the case of X, Y, and XX. And I would say a key reminder to professionals to make sure they're on top of all of the issues in the case, simply because a client says something doesn't attract CGT or doesn't need to be revalued or valued, that appropriate advice is given, rather than a client coming to you, the solicitor or the barrister after the hearing, and saying, well, I've just revalued this, the value is different, can I apply to set it aside? And then what may be looked at, I mean, if the client's told, well, no, he does have a remedy in approaching his or in issuing negligence claims, essentially, then you're then on the back foot of trying to assess whether or not you've given appropriate advice or not. I hope that's helpful. That concludes the seminar. James, do you have any points to add to what I said?
I only to sort of encourage anyone with a bit of spare time who hasn't already read it to read the judgment, because the first instance case actually is a really good example of a case where a husband has tried to collude to conceal quite a substantial number of his assets, and he was found out for that. So he was already on a pretty bad faith footing when he brought the set aside application. So you see the judge is fairly unimpressed in general, and also considered the fact that the wife, it would be unfair to put her through another set of expensive and uncertain litigation, given the circumstances of the case. So everything is case specific. We always say that it's sort of unhelpful, and it's helpful to say it's case by case basis. But there overall is a reluctance to set aside orders. So that's why there's so few applications that we come across compared to other types of applications. But they can be legitimate grounds. So it's important to consider that if your client comes back to you in a few months after a final order and says, look, things are totally different, it is worth looking into it just to see whether or not there's a reasonable prospect of either seeking to set something aside or not. So Zubair, I just wanted to well, before we finish the seminar completely, obviously there's probably so 5 minutes left for questions. Anyone feel free to write those in. I can see, Zubair, we have a question already, so I'll read that out.
Sure.
I'm not sure everyone can see the chat that I can. So the question is, if parties have written to the court after FDR to state that they have reached an agreement, but later one party withdraws from the agreement, and as such no consent order is finalized, signed, or sent to the other side, and presumably the court, will the parties be bound by their agreement? So I'm wondering, is this is in between FDR and any final hearing?
Yes.
An agreement's been reached, and then one party's resolved from that
Well,
agreement.
I suppose, I mean, until the order's sealed, I mean, yeah, I mean, the appropriate thing probably to do is to write to the court office, or the judge, and indicate what's gone on, as to whether or not, yeah, I mean, as to whether or not the agreement is actually reached or not. But I suppose that's not, I mean, that's sort of a situation before an application to set aside is actually being considered because the order hasn't been sealed and finalized yet.
Yeah. So I mean, is it has the agreement been reached in open correspondence, in which case it can be shared with the court, perhaps at a later date, if you want to challenge the party's new position. If it's on a without prejudice subject to cost basis, then you might be able to raise it at the cost stage. But it would seem to me that any agreement between solicitors which has not yet been crystallized into an agreed order that's been approved isn't finalized, and so there isn't going to be a legal binding, but there may be an opportunity for either a strategic negotiation, given that you are going to essentially say, look, I will be sharing this correspondence and this provisional agreements with the court um, at a later opportunity, whether that's at a further case
Yeah.
hearing or a final hearing.
Well, what I've had, yeah, I mean, James, I don't know if this helps, but I mean, what I've had is a situation where parties have reached an agreement. Well, it appears that the parties have reached an agreement. They tell the judge that we've reached an agreement, and then when it comes to the finalizing of the order, we tell the judge, well, no, there's not an agreement, and the judge then lists the hearing to deal with the issue. I don't know. I mean, different judges may take a different approach, but I mean, what's important is that the judge knows is that, well, no, there's not actually, in fact, an agreement before the order is sealed.
I think that the question at the end is, are the parties bound by it? I think the answer is strictly no.
Yeah,
But there might be pressure to negotiate something around that, or to seek an adjournment for a non-court dispute resolution option
yeah,
if it looks like between the parties there's still prospect of reaching an agreement, even if that particular term of agreement has been um, discontinued by one party.
yeah.
Um,
All
so
right. I mean,
yeah, good question. Nothing else on my chat. I don't know if you have it in front of you, Zubair.
no, that's the only question I can see. There's nothing else.
No, hopefully, I mean,
Well,
it was a back to basics presentation. So there might be some complexities or nuances that we haven't gone over. If any question occurs, please feel free to email
yeah,
at a later or more convenient point. And otherwise, keep your eyes out for future webinar series. I'm sure there'll be another one in the autumn, if not before.
that's great. Thanks a lot, James, and thank you to everyone who's attended.
All right. Bye bye, everyone. Have a good evening.
Thank you.